Okay. Hi, I'm Kate Selby from HRD, and this is our October training session on Family and Medical Leave Act. We have about 70 people signed up, and as you can see, a lot of them are doing the live streaming, which we really think that's a great option for people, especially those that are located all around the state. And we're going to try to encourage people that are doing the live streaming to ask questions. And on Matt's link, there's a section for chat. Is that the correct?
Yeah, it's a chat section right next to the video.
It's the chat section right next to the picture, and you can write in a question and send it in, and we'll ask our speaker to answer the question. You could also send Susan Hoyt. She's one of our HR professional staff, and she's got a laptop here, and you can send her an email if you have a problem with the chat, or use the Google chat to try to get to her. And we'd like to see as many questions as we can from the field, because so far in all of our trainings we really haven't had any questions. And this is the question box, which is to help you ask questions. When you don't use a microphone, the recording doesn't pick up the question, so this way everybody can kind of share and pass it along and toss it, but not throw it kind of like a football. So
The idea is to throw that, and then if you toss it, might throw it and broke it.
So the plan is to have Van Snow, an Assistant Attorney General, make a presentation on the Family and Medical Leave Act. Please feel free to ask, well, unless you'd like them to wait till the end.
Well, you can chime in at any point, but I was going to have a question and answer period at the end.
So if you need to ask at the moment, you can, or you can save questions for the question and answer period. We also have Debbie Russi with us. She's with the A&I Agency HR, and she'll just take a few minutes after the question and answer period to tell everyone what A&I has done as an agency to update their family and medical leave process and paperwork, just as a method of information sharing. And I know large agencies have established practices, but some of the small agencies maybe need to have some things to share from the bigger agencies. So that's just 5-10 minutes of discussion on what an agency is doing. So I will turn this over to Van Snow, and I'll leave the question box here.
Okay, thanks. Well, hi everybody. I'm Van Snow. I'm a personnel attorney at the Office of the Attorney General, and thanks for showing up and for all the I didn't know we'd have that many people online watching, so thanks everybody for tuning in. I've been asked to give kind of a refresher update on the Family and Medical Leave Act. And so I was planning on breaking that down into approximately 2 parts. In the first part, we're going to cover FMLA leave basics. And for some of you experienced HR folks here, this might be a bit of review, but I just want everybody to be on the same page. And then in the second part, we're going to talk some specific issues with implementation of FMLA leave. And there we'll discuss things like notice requirements, certification, and prohibited acts, what the FMLA protects. So we were saying initially, feel free to ask a question at any point. We have the Kleenex box looking thing with a microphone. And we're also going to be fielding questions online. Also, if I'm blowing anybody online, if I'm blowing out your ears with the mic, just let me know. All right, so to get started, we're going to start with FMLA basics. So the basics of the FMLA are this. An eligible employee may, for a qualifying reason, take job-protected leave, and it's usually for 12 weeks, although as we'll see, there's a weird exception where you get 26. So we're just going to go down that list and kind of break it down. So an eligible employee needs to have been employed with the state for at least 12 months. And in the 12 months immediately preceding when they take leave, they need to have served at least 1,250 hours. And if you crunch the numbers over 52 weeks, that works out to about 24 hours a week. So if you work 24 hours a week for the state for at least 12 months before you take FMLA leave, you pass that initial step and you count as a qualified employee. One more wrinkle is the provision that there need to be at least 50 state employees within 75 miles of the workplace. I don't know if this will ever come up. Maybe there's some employee just kind of working off in the middle of nowhere. If you think that'll be an issue, talk that through with your personnel attorney, because there are some wrinkles as to what counts as a work site. But that's the basic threshold for determining if an employee is eligible. So if they're an eligible employee, they can take job-protected leave. And to kind of break down what that means at its core that you're entitled to, once you finish taking your FMLA leave, you're entitled to get your job back. Or if that's impossible, you're entitled to get a job that's pretty much the same, that's substantially equivalent in terms of pay, in terms of your responsibilities, and in terms of your benefits. It's also job protected in the sense that if you were going to get automatic benefits, everybody's getting bumped up with some sort of pay raise or something like that, you're entitled to get those when you come back as well. Now, there are a couple of exceptions to this job restoration requirement. One has to do with key employees. A key employee is a salaried employee who, if you look at all the employees within 75 miles, is in the top 10% of pay. And I think the logic behind this is if you got a director, somebody like mission critical, the Congress realized it'd be a bit of a burden on employers to mandate that we keep that job open. But even there, it's a pretty high threshold. We have to prove that there's substantial and grievous harm. That's a very high threshold that would result if we leave that position open. So if you think that'll be an issue, be sure to talk it through with your personnel attorney. And another exception is if somebody's taking FMLA leave for a serious health condition, and it's really serious, and their FMLA leave runs out, but they're still unable to perform the essential functions of the job. In that case, we may not be required to have that job restoration. So it's also job protected in the sense that you can't hold their use of leave against them. And this kind of makes sense, and we'll get into it a bit later in the presentation when we talk about FMLA protections. But basically, you can't discipline somebody because they were out of work. So FMLA leave is unpaid, but it interacts with leave that they've accumulated. So for instance, if out of the 12 weeks of FMLA leave, if they have 2 weeks of accumulated paid sick leave, the state can require that that paid leave run at the same time. So they would get 2 weeks of paid leave, but then the rest would be unpaid, and it would use up all their sick leave. And I think the logic there was to prevent people from taking their FMLA leave and then their leave on top of that and being out for a really long time. But it can also, as we'll see with health premiums, be a benefit for the employee too. And there's also, if you come up with a situation where somebody gets hurt on the job, files a workers' comp claim, gets some leave through there, and then wants to take FMLA leave on top of that, there can be weird interactions. So be sure to talk with your personnel attorney if that sort of thing comes up. Oh, okay, there we go. So some other job protection benefits. So health benefits, that's a big one. And generally, you're entitled, we just are supposed to treat employees taking FMLA leave the same as if they were still working. So that means we still have to pay contributions on health insurance. But it also means that they have to still pay premiums on their health insurance plan. And if they have paid leave, as I was just talking about, accumulated, this can really help employees defray the cost. However, if they decide that it doesn't make financial sense for them to keep making those premiums, they can opt out of the group health insurance program temporarily. But once they come back, they're immediately eligible to re-enroll in group health insurance. And so when we're talking about benefits other than health insurance, the general question is, yeah, if this person were taking normal leave, personal time, and some sort of benefit accrued, would they be entitled to that benefit under normal circumstances? And if you have questions about whether things like, like I was saying, kind of annual pay increases or pay increases depending on performance would apply, you can talk that through with your personnel attorney. So now that we've covered the job protections and covered what makes you an eligible employee, let's talk about the qualified reasons. These are the actual reasons for which you can take FMLA leave. And there are 6 of them, I think. Yeah, 6. So the first is birth of a child and care for a newborn. The second is placement of a child through the adoption process or through the foster care process. The third is care for a family member with a serious health condition. Fourth is employee's own serious health condition. The 5th and 6th have to do with a service member. So the 4th or 5th one, I guess, is emergencies that arise out of a family member being put on active status with the armed forces. And the last has to do with caring for a service member who gets injured in the line of duty or an injury gets aggravated. So before we dip into those 6, just to get a definition out of the way. A lot of these talk about family members. And when we're talking, these are supposed to be in red. It's not really showing up very well. When we talk about family members, what we're talking about are spouses, parents, and children. So spouse is pretty straightforward. Somebody you're married to, somebody you're in a legal marriage with. And after recent court decisions and after more guidance from the Department of Labor, this does include validly married same-sex couples. So this one's pretty easy. If they're in a legal marriage, that's a spouse. So parents, when we talk about parent, that means your biological parent. That's pretty easy. Somebody who's officially adopted you, your step-parent or a foster parent, and anyone in loco parentis. And you know that this is a presentation about the law because we're using Latin when English would serve equally well. That just means in place of parent. So a lot of times this comes up with grandparents. A grandparent basically is the parent. It takes over, cares for the kid financially, picks them up from school, that sort of thing. Notably, it does not include in-laws, although there's one small wrinkle to this we'll see later. Children, it's kind of like the mirror image of parent. Your biological kids, kids you adopt, foster kids, if you're a ward of a kid, your stepkids, and anybody that you're in loco parentis to. So that's just the mirror image. Also, a child must be below 18. However, a child can qualify if they're over 18, but only if they have a mental or physical disability that makes it impossible for them to care for themselves. So the first of these qualifying reasons, the birth of and care for a child. So this qualifying reason is meant to allow new parents to bond with their kid. And since that's the purpose, note that both genders get access to this one. It's not just the person who gives birth. However, there is a slight interaction. Pregnancy can be a serious health condition, so it's possible that the person actually giving birth can get FMLA time for health conditions associated with pregnancy and then also qualify for birth of bonding with the child. So either the parents can take this leave anytime within a 12-month period from the birth of the child. And there's kind of a special, it's not really an exception, a special wrinkle. If both parents are employed by the state, the couple as a whole gets the 12 weeks. And they can split this up. So they can have one person take all 12. They can have both people take 6, in which case, as we'll see later, they'll each have 6 left over for their own reasons. So the second qualifying reason, placement of a child, is pretty similar. The goal is bonding, so both parents qualify for it. And you can take the leave for the actual placement of the kid and bonding with the child, and also required activities. So if in order to adopt the child, you have to attend hearings or you have to get some sort of evaluation from DFS, something like that, you can take the leave. Again, 12 months from the placement, or, and there are similar conditions to the birth and care. This is just children, but in a different circumstance. So before we get into the next ones, we need to define serious health condition. Note that when we're talking about serious health condition, we're not talking about, or this is a distinct concept from disability under the ADA. Now, oftentimes there are very interesting interactions with the ADA and FMLA leave. But note that when we're talking about FMLA leave, we're just talking about this. So there may be a single diagnosis that gives rise to obligations under the ADA and the FMLA, but the FMLA leave, we're just going to look at this. So a serious health condition is an illness, injury, or impairment, and it needs to involve one of two things. So if you get inpatient care and you stay overnight at a hospital and there needs to be treatment after that, that qualifies. The other prong is an illness, injury, or impairment involving incapacity requiring continuing treatment by a healthcare provider. And the regulations for the FMLA break down, I think that's 4 or 5 things that count as incapacity requiring continued treatment. So the first is if you're incapacitated, you can't come to work for 3 or more days, and as part of that, you need to get treated twice by a doctor within 30 days. Or this could also be you go in to see a doctor once and they say, look, this is the only time you need to see me, but you need to do a bunch of other stuff. That could still qualify. The regs also specify that pregnancy and prenatal care qualifies. So if an expecting mother can't come in because of morning sickness, she doesn't need to go in and see a doctor and them to say, yep, it's morning sickness. Just stuff associated with pregnancy can count. Chronic conditions, and this usually describes things like asthma, a lasting condition that has kind of flare-ups that can incapacitate you. Similar thing, you don't need to go to the doctor every time you have a flare-up, but you can still qualify for FMLA leave. Long-term conditions usually means things, I think the example they use in the regulations are long-term things that may not necessarily have a cure or way to treat them. Things like, I think they use Alzheimer's as the example in the regs, leave associated with that. And also just anything that requires multiple treatments. So as we see, this is a pretty broad definition. And we need to keep that in mind going forward. So with our definitions, the next qualifying reason is actually pretty straightforward. As long as you're caring for a family member, as we've defined it, and that family member has a serious health condition, as we've defined it, you can take leave. Pretty straightforward. Similarly, with the employee's own serious health condition. If you've got a serious health condition, you can qualify for FMLA leave if you're unable to perform the functions of the job. And the regs talk about a specific wrinkle with substance abuse. Treatment for substance abuse can qualify, but note that's the treatment for the substance abuse. And we can still have substance abuse policies saying don't abuse substances. So the next exception are exigencies, or again, that's kind of an unnecessarily complicated legal term, just emergencies that happen when a family member who's a member of the armed services gets put on active status. And the regulations specify what those sort of exigencies will look like. So anything that comes up, they get put on active status, they need to report somewhere, you need to take them, you have less than 7 days notice, that counts. Military events, that counts. The next two have to do with changes to your life that somebody being put on active status entails. So if you need to work out a different schedule for somebody picking up the kid, if you need to update legal documents or investment documents, you can take off time to talk to your lawyer about that. Similar with counseling for family members about that absence. Spending R&R time when they come back. Post-deployment activities, reporting to a muster point or some sort of ceremony. And this is that slight wrinkle we're talking about. If it's needed to care for the service member who's getting put on active status's parent. In that case, in-laws can count. And the last one is caring for service members' serious injury or illness. And note a slight difference in terminology. We're talking about serious injury or illness. We're not talking about serious health condition. So a serious injury or illness is something that they suffer in the line of duty or a pre-existing condition that gets aggravated that renders them unable to perform the duties of their position in the military. In order to qualify for this, you need to be a member of the armed services. That includes anybody in the 5 service branches. It includes the National Guard. It includes the reserves. And the person giving care to qualify needs to be, as we've defined it, a child or a parent, or it needs to be their next of kin. So, say you meet all those things. You're a qualified employee. You have a qualifying reason. You want to take your job-protected leave. How much leave do you get? The standard for all of those qualifying reasons we talked about, except for one, is you get 12 work weeks in any 12 months, and the state rules specify that that 12-month period starts forward from when you take your FMLA leave. State rules also specify that your paid leave is exhausted first. So if you have that accumulated sick leave, that accumulated personal leave, that gets burnt through first. The one exception to the 12 work week rule is that last exception we talked about. Service members with serious injuries or illnesses, you can take up to 26 weeks, half of a year, to care for that service member. And we talked briefly about splitting leave between spouses. That just kind of generally applies when both of the people who would qualify work for the state. So things like the child care one or caring for somebody with a serious health condition, that gets split if 2 people are eligible. And the total leave that somebody takes for multiple FMLA qualifying reasons, say they, for 6 weeks, have a serious health condition, and for 6 weeks they're bonding with their child, they can do that. But they can't exceed that 12 work week cap. And if you qualify for the 26-week exception, your total leave can't exceed 26 weeks. So you can also take your 12 weeks on, you can take it all at once, and that's the easiest way. But you can also take intermittent or reduced schedule leave. So by intermittent leave, that's contiguous blocks, or I guess non-contiguous blocks, all at once. So you show up to work for 3 days, you then take 2 days FMLA leave. The next week you take 3 days FMLA leave, go back to work for 2 days. And by reduced schedule leave, I mean you keep showing up to work every day, but you only work 4 hours a day, and you use your FMLA leave for each of those 4 hours. So your eligibility for this depends. It depends on if you're taking it for one of those medical reasons we talked about. You can qualify for it, but only if that's the best way to accommodate the serious health condition in question or caring for the service member. If you want to take intermittent leave for the birth or placement of a child, the employer gets to say, that won't work for us. So it's only if approved can you take intermittent leave for one of the child-related ones. And if it's a qualifying exigency associated with the service member getting placed on active status, because those are by definition exigencies, emergencies you can't really plan for, you just automatically get that. However, with all these, even if you get intermittent or reduced scheduled leave, the employee has a duty to try to work with the employer to kind of reasonably schedule things like health appointments that they're going to need. Yes?
I'll take the box.
Oh, yeah.
I had a question on the, you mentioned morning sickness.
Right.
So the employee has to let their boss know that they are pregnant ahead of time, and then there is no way to schedule random morning sickness.
Right.
And so they just call up and say, I'm not coming in, or they can use the intermittent leave that way?
Yeah, so actually we're going to kind of discuss that when we talk about notice requirements. So
That's fine.
yeah, once we get through that, let me know if you still have that question.
Okay.
And also, in rare cases where somebody qualifies for intermittent leave and really the only way to make that work is to temporarily transfer them to some other position, that's possible. However, you should definitely talk this through with your personnel attorney because it can raise a bunch of other issues. So that's FMLA basics. And in the second part of the presentation, we're going to go over how you actually implement that. And we're going to talk about employee and employer notice because both people have duties here. We're going to talk about certification, especially, we're going to focus on medical certification, but there are other types. We're going to look at what sort of records you need to keep, and then we're going to look at bad things that hopefully aren't going to happen. Hopefully we can give everybody the leave that they want and not have to deny anybody, and we're definitely not going to do any of the prohibited actions. So first, okay, yeah, actually, before we get into the weeds on this, there are a lot of details, but the basic process is pretty straightforward. And it's actually laid out very nicely in one of the handouts that's included in these course materials. I think it's not the, well, actually the notice requirement one is good for what we're going to be talking about right now, but there's a nice flow chart in the employee guide to FMLA leave, and that's kind of a good way to walk through graphically what we're going to be talking about. So first, the employer has a duty to make people aware of their FMLA rights. So the easiest way, and actually one thing that's specifically required, are posters. We have to put up posters in conspicuous places where people can see them, advising them of their rights under the FMLA. And if you don't have these for whatever reason, I'm going to show you a link at the end of the presentation where you can get them. We also need to, as part of the onboarding process, advise people of their FMLA leave. If your department has a handbook, that's a good way to do it. Otherwise, we just need to give them some sort of documentation, and I think A&I's probably has that worked out somehow, advising them of their rights. So here's where we start with that process. The employee comes to the employer, and they say one of two things. They say, hey, I want to take FMLA leave. That's very straightforward. Or they say, hey, I need to take leave because my kid has a serious health condition. We need to go to a bunch of doctor's appointments. That's giving us notice that the leave they take may be for a qualifying reason. So once that happens, it starts a 5-day clock ticking. And sometime before that clock expires, we need to give them an eligibility notice. And this eligibility notice is just a form. And that form will tell them if we believe that they're eligible for FMLA leave. And that's kind of that process we were talking about in the first part of the presentation. Have they worked for 12 months? Have they worked for the 1250 hours? And if they pass that threshold, we need to advise them of that. Additionally, the eligibility notice has language advising them of their future rights and responsibilities. So we need to get that out as soon as they tell us FMLA leave, or we think that the leave will qualify.
Can I ask a quick question? So if someone, if they have like 300 hours of sick time and they come and they have some issue going on, do they have to do FMLA? Or if they're, if they're saying, oh, I'm going to take 2 weeks off and they have the leave, do they need, how do I know when they should do FMLA or when they shouldn't, even if they're going to be taking intermittent leave because their child is sick for the course of a couple months? If they take off a total of 40 hours over that time period, is FMLA required?
So that's a good question. So they don't have to take FMLA leave, even if it's for a qualifying reason. But we have the duty to let them know they can. And so they could just take sick leave and choose to pass up the protections of the FMLA leave, but we need to let them know. So then once we start that process, and maybe this will, oh yes, could we get the,
I just had a question that you just said, that an employee can waive their right to that.
mm-hmm.
I was under the impression that they can't, and that it's the agency's or the employer's responsibility to designate that it is FMLA leave or not.
Right, yeah, and you're right, and I misspoke. What I meant is that they ultimately don't have to take FMLA leave. So we can designate it and say, this qualifies, but if, for instance, we go down through the certification process and we're asking them for medical certification and they don't provide the certification back, and we designate it one way or the other, they don't end up taking the FMLA leave. So you're right, we still need to go through this process, but ultimately if they don't want to take FMLA leave, we designate, but they don't have to.
Even if our rules say that, well, I guess where I'm confused is if I were pregnant and I said I don't want to take my family medical leave, isn't it the employer's responsibility to say, yes, I'm placing you on FMLA leave and we are using your 12 weeks?
Yeah, you might be right about that. I misspoke. So yes,
Okay,
we need to designate.
So an employee, I guess I just want to be clear, because, when I was in the agency, I had that happen all the time. The employee would say, I don't want to take FMLA leave. I just want to use my sick leave or my vacation time. I don't want to use FMLA leave.
Right. Yeah, you're
So
right.
we have to place them on leave if it meets a qualifying condition, if they're eligible, and we use their family medical leave in conjunction with their paid leave.
Yes, yeah, you're correct about that. We still have to go through that process.
Okay, thank you.
So once, and hopefully this will happen at the same time, once we get enough information to say whether or not somebody will qualify, we have to send out a designation notice within 5 days, and that's designating whether or not they qualify for FMLA leave. And although the designation can take place at any time, or within those 5 days once we receive enough information, we can retroactively designate if we find out later that earlier they qualify. Yes. Sure.
So going back to what Lori was asking, my confusion comes in with, okay, so I have an employee I know is going to go out for surgery. It's supposed to be in and out. He's going to come back, doesn't want to use FMLA. There's some sort of a stigma attached for some folks. But I give him the paperwork, say, this is available to you, and give him the information that it protects his job status and his employer's contribution and so on and so forth. And he tosses the paperwork away. I don't get that medical statement, so then how can I designate that it's FMLA?
Right, exactly. And yeah, I think that's where the confusion arose. We need to make the designation. That doesn't mean we need to approve it. And ultimately, if they don't provide enough information to us to designate it as approved, then yeah, the FMLA process doesn't go forward because we've designated that as not qualifying. So yeah, just to clear everything up, yeah, we have the obligation to go through with the designation process. Whether or not the designation goes through will depend upon information that we receive.
Okay, but so we have an employee that knows the rules, so they say, I'm not taking it, they use all their leave, then at the end of using all their leave, they want the 12 weeks. So they've now extended it because we're saying that we're not going to make them take it?
Yeah, but you can retro.
Right. Yeah, that's exactly right. So if we find out, if we get the information to designate as FMLA leave, it can be retroactively designated as such. Yeah.
And I think, and correct me if I'm wrong, but under our personnel rules, leave has to be pre-approved. So if an employee fails to turn in their certification and we don't place them on FMLA leave, and they are then wanting to use sick leave, that can be denied, and in essence, they're not protected for not showing up for work. Is that correct then?
Yes.
I mean, we don't want to go down that road, but that that's what would basically happen is if the employee doesn't return their certification and they are using their leave, you don't have to approve the use of leave. And then if they don't show up, then you're in the discipline part.
The problem is that we're paid in arrears. So a lot of times we don't know till we see the time cards coming through. The supervisors don't let us know. So we've got that issue going then.
So is the question that you may not know until after leave's taken? Yeah, so
Well, we can't deny them taking their leave if the supervisor allows it, because we don't know. It's too late when we find out.
right. So that might be an implementation issue to work through within your agency to streamline that process.
So, yeah, I'm not going to break it this time. So, like, I have an employee and her daughter has kind of a rare form of cancer, and she has, 300 to 400 hours of sick leave. And so she said, oh, I'll just take the sick leave and I don't need the FMLA. So I should go back in this situation and because I feel I've made a mistake because I didn't, she said she didn't want it, so I didn't do it. I was like, oh, okay, well, she's got a ton of sick time, no big deal. But I want to make sure that I'm doing what I'm supposed to be doing. So should I go back and do the FMLA paperwork with her?
Yeah, and I should have mentioned this earlier, with, specific questions about specific cases, I'm not in a position where I can give good legal counsel because I'm, up here in front of 70 people. So, specific questions, I would advise you to talk with your personnel attorney about that. If I am your personnel attorney, just call me up after this and we'll work through it when I can actually sit down and give good counsel about specific cases. Okay. So we've talked about eligibility notices and we've talked about designation. That needs to happen one way or the other. So the employee needs to give notice as well. And if it's foreseeable leave, if they know that they're pregnant and they have an expected delivery date, or they know 30 days out they got to see a specialist for their health condition, they need to notify the employer within 30 days. And if that doesn't work, if something comes up, a specialist appointment opens up with less than 30 days, they need to notify as soon as is practicable. And as part of that notice, they need to, and this is getting to what we were talking about, they need to provide sufficient information for us to be able to make a determination. And they can choose to give that in whatever form they want. It can be verbal, it can be written. And as I was saying earlier, they don't need to explicitly mention FMLA. We can ask some limited follow-up questions, about time and stuff like that. And we can also request certification. And that's really what we're getting at. So that certification and the information we get from that will enable us to make the determination decision. So generally, employees, when they're requesting leave, they need to work as closely as possible with our usual procedures for requesting leave, unless something weird's going on. And if they know in advance they're going to need intermittent leave, they need to work out a schedule as close as they can with the employer. And if there's unforeseeable leave coming up, it's just as soon as practicable. And we need them, again, to comply as closely as possible with our procedures. The regs use the example of if your child has an asthma attack and you have to run home, grab the inhaler, go deliver it to the child, make sure the child takes it and is safe. You're not required to call in while you're on your way driving to see your child, but you are required to call in once things calm down and let them know what happened. And generally, you just need to treat this like foreseeable leave in terms of content. And this is another, I think this was a question that came up. So if you're calling in to get FMLA leave for an unforeseeable thing, and it's been previously approved as an FMLA condition, you need to give the employer enough to know it's for a qualifying reason or for that FMLA approved condition. So you can't, if an employee gets FMLA leave approval for a health condition, it won't be automatic and it won't necessarily qualify as FMLA leave if they just call in and say, I'm sick. They need to give something more than that. They need to say, I'm invoking this previously approved FMLA leave, or this is related to the condition that I told you guys about. So does that answer the morning sickness? Okay. So if an employee fails to provide notice or the certification we're talking about, it can result in delay of leave. But in order for this to even apply, we need to prove that we've given them the proper notice, that they're the posters, that we've advised them of their rights, and that we've given them that eligibility notice. If in the case we need to do that, delay is not a punishment mechanism. It's just, if necessary, to kind of cope with and structure our business arrangements to cope with this thing that's come up. So if the delay, or if the need for leave was foreseeable 30 days in advance, it can be delayed up to 30 days. And other than that, if it was foreseeable less than 30 days, or if it was completely unforeseeable, it just kind of depends upon the circumstances. And under the regs, we can waive this requirement and choose not to delay, although under the personnel rules, there is still the duty that the employee has to try to give notice. So medical certification, and this is what we were talking about earlier. Medical certification operates to give the employer enough information to make the designation. So medical certification is something that we ask the employer or the employee to give to their doctor, for the doctor to fill out and send to us, to give us the information to make the decision. So we need to request this when they give us notice that leave may be for an FMLA qualifying reason, or within 5 days of that. And then the employee has 15 days to get it to the healthcare provider for them to fill out. And in order to qualify, a certification needs to be complete and sufficient. So an incomplete certification is one that just isn't filled out, that there are areas missing that the doctor didn't cover. And an insufficient certification is one that's fully filled out, but you can't really tell what's going on. Recently, I worked with an agency on a really good example of an insufficient certification. It was fully filled out, but just looking at it, you could not in good faith tell what was going on, if leave was going to be necessary. So if either one of those things happen, you get a certification that for whatever reason doesn't work, the employee gets 7 days to cure it, to go back to the doctor and get it fixed. And all these things, the certifications, we use just kind of standard forms that the doctors should be able to understand. So just kind of some issues there relating to clarification. So we can, if we get back this certification, the department can talk to the doctor and make sure that the form is valid, or to clarify things, but you need to be careful here. So first of all, the direct supervisor can under no circumstances talk to the health employer. This should be on the HR side of things. And the purpose of checking validity and to clarify issues is not to dig deeper and get more medical information, but it's instead to make sure, hey, did you actually fill this out? Or to clarify kind of the meaning of a sentence, that sort of thing. And if after getting the certification we don't agree with it, we have reason to believe that the diagnosis wasn't good, we can require a second opinion. And so the employee will need to go to a different doctor and get a second opinion. And if the second opinion disagrees with the first, we can then send back for a third opinion from a different doctor. This is a long and process that requires some cooperation between the employee and the employer, and you should walk this through with your personnel attorney.
Okay, so if the agency's requiring them to go to another doctor, who pays for it?
I believe that's the employer for the second opinion. Am
Okay.
I right about that? Yeah. So recertification. This would be at the employee's expense, and we can request, usually it's know more often than every 30 days that they go through the certification process again. And there are a couple exceptions to that 30-day rule. If the initial certification we get back indicates that this condition is going to last longer than 30 days, we can't then every 30 days say, hey, is this condition still around? Additionally, if there are significant changes to circumstances, or if something comes up that makes us doubt the certification, we can request in fewer than 30 days. So when an employee exhausts their FMLA leave, we can require periodically through the FMLA process, we can require them to provide notice of their intent to return to work. However, it's only if they kind of unequivocally say, I am not going to come back to work after my FMLA leave, that we know that we won't have to bring them back and we can start that process. We can also require fitness for duty examinations, but there are a couple of caveats here. The first is that we need to advise them that a fitness for duty request may be required, and I think, and correct me if I'm wrong, but I think that's on the determination form and not the eligibility form. It's on one of them, notifying them that it will require a fitness for duty test, and it needs to be a uniform policy for similarly situated employees. And similarly situated refers to both their position, but it can also refer to their health condition. So if we require that people with certain conditions need to get a fitness for duty test, that can be fine. And it also needs to be job related. So you can't, the example that I've seen used is that you can't require an attorney, if they hurt their back, you can't necessarily require a fitness for duty exam because they can do their, perform their duties even if they have a hurt back. But for somebody who's going to be using their back a lot in work, that might make more sense. So some record keeping requirements. So in general, we need to keep FMLA associated records for at least 3 years. And the regulations spell out what you need to keep. And you can find those in the FMLA regulations. And here are some of the ones they mention. Actually, record keeping for when people take FMLA leave. And, and we need to keep track of the hours if they're taking intermittent leave. Also, we need to keep copies of notices we've provided to employees and notices we've sent out, those eligibility determinations. And we also need to keep any documents that we provided describing FMLA leave and protections. We need to keep records of the healthcare premium payments, and also anything having to do with a dispute. If at any point during the process the employer and the employee were disagreeing about something, keep the records associated with that. So stuff like medical certifications need to be kept in a separate file from the personnel file. So you'll need to maintain a medical file and a personnel file. And that medical file needs to be held confidential. And a lot of times people have questions about what can be shared about somebody's FMLA qualifying reason, particularly if it's a health condition. And the regs talk about this in kind of a need-to-know situation. Supervisors and managers need to know some kind of basics, what the employee is going to be restricted from, or how we're accommodating that. But they don't need to know diagnosis and that sort of thing. They don't need to see the certification. And safety personnel, they need to know if they're going to be called upon to provide emergency treatment for this person. So that makes sense. So denial of FMLA leave. So to note, this is denial. This is not requesting recertification. This is not requesting clarification from the doctor. This is when we say, no, you do not qualify for FMLA leave. This, you need to go through A&I HRD to get authorization. You need to get a written request. And if you haven't brought your personnel attorney into the loop before this, bring your personnel attorney into the loop before this. Prohibited actions. So these are the protections that the FMLA has. I know nobody in this room or watching this is going to think to themselves, hey, I really want to deny Bob his ability to exercise his FMLA rights. But this is just good stuff to keep your antenna up when you're kind of considering FMLA issues. you need to think, is this going to look like we're interfering with or restraining or trying to stop somebody from exercising their FMLA rights? Are we trying to take some sort of disciplinary action against somebody because they were complaining that we were preventing somebody from exercising their rights? Or are we taking an adverse act against somebody because they started the process with the Department of Labor to file a complaint or to try to have the Department of Labor investigate? So, and just some authorities and resources, some useful things to draw on. The actual statute, the actual FMLA leave, is found at 29 United States Code, Section 2601, and the following statutes. That's just kind of there for reference. I don't think it'd be particularly edifying to review. The regulations, however, are how the Department of Labor is implementing the Family Medical Leave Act, and that's found at 29 CFR Part 825 and the following. And these are actually extremely useful. They're very dense and not a lot of fun to read, but they have a lot of information and just kind of go step by step through this process. And then the state's policy on FMLA leave can be found in the personnel rules, Chapter 6, that's leave, and then Section 16. Now, the personnel rules are kind of implemented on top of the regulations in the statute. They're just how the state is choosing to exercise its options. There should never be a conflict between the rules and the regulations. If you think that you're in a situation where you have conflicting obligations under the rules and the regulations, talk to your personnel attorney. And then generally, this is the link that I told you all about earlier. The Wage and Hour Division is the part of the Department of Labor that deals with FMLA issues. Their website has all sorts of useful information, and it also has resources like those posters I referenced, how to get that. So, opening up to questions and answers.
We have a couple questions that came in from out in the field. The first question is, if the employee comes and states to the supervisor that they will have surgery in 2 weeks, do they have to have the certification to approve the FMLA?
Yeah, there needs to be enough, because that would be taking it for a serious health condition. So we need to have enough information to determine whether or not that qualifies. So yes, a medical certification would be needed.
Okay. Our second question is, if an employee is taking care of a parent at home, do they have to have the certification?
Sorry, could you...
If an employee is taking care of a parent at home, do they have to have the certification for that?
Yes, if they're taking care of so they're presumably taking care of the parent because the parent has a serious health condition, you can require certification of the parent's health condition.
Okay. We have another question. When an employee has exhausted the 480 hours, when do they start the time over to requalify them?
To requalify. So you can't take more than the 12 weeks within a 12-month period starting when you first take the leave. So, I mean, I'm not sure if that answers the question. There would then be a 12-month period where they wouldn't be eligible to take any more FMLA leave. And then once that 12-month period is exhausted, then they can requalify for more.
Those are all the questions that were online.
Okay.
So the last question came in and they referenced specifically 480 hours. And for most full-time jobs in the state of Wyoming, they're 40 hours a week, which 12 weeks would be 480 hours. But we have part-time employees who might work regular scheduled 6 hours a week, or sometimes we have mandatory overtime where an employee is scheduled to work 48 hours a week. So am I correct that the employee who is regularly scheduled to work 6 hours a week would get 6 hours a week, a day, 12 weeks? And somebody who works 48 hours every week would get 12 48-hour weeks, not just the 480 hours. So it would be actually more hours based off of what they're regular scheduled to work.
I don't think I understand your question.
The question that we had over there, they referenced 480 hours.
Okay,
So that's 12 times 40 hours a week.
okay,
If an employee who is regularly scheduled to have mandatory overtime and they work 48 hours every week, they get 12 48 hours of family medical leave, which is more than 480 hours. Well, that's my question. They are regularly scheduled and they work 48 hours every week throughout the year. And if they're entitled to 12 work weeks, their work week is a 48-hour work week. So they should get 12 48-hour work weeks. Is that correct?
no, I believe they just get, you know, the equivalent of 12 work weeks.
How do you define a work week, though?
Yeah, I think that would just be on a full-time basis, but
One doesn't get, but if they always work, can we maybe have you research that and get back to us?
Yeah,
'Cause
sure.
we have that. That comes up a lot.
okay.
Thank you.
I think it's 480 hours or 12 weeks, whichever is less. I was just saying, I think, just based on experience, and this is outside of the state, but I've had that issue come up before, and it's 480 hours or 12 weeks, whichever is less, in that case that you were talking about with the 48-hour work weeks. At least that was the way in which the corporation I worked for interpreted that law for purposes of implementation.
Yeah, that might be the case. I'll have to look into that. Are there any other questions or comments or? Okay, I think that Debbie had some updates about A&I's side of thing.
Go ahead and take the tissue box.
Well, put this here so I don't have to hold it. So what we did at A&I was we made a process, and if we, like Mike said, if this lady came in and asked to take maternity leave or taking care of a daughter and they didn't want to do FMLA, we gave them a letter of possibility, a notice of possibility, giving them their rights. So that way they cannot come back and say they don't have those rights. We also have a request form that we created that the employee signs, and they don't have to put out there that there's FMLA. They can just say medical leave. And it just kind of gives us information that will send out that notice of possibility. Then once they turn in that request, we have a letter of eligibility notice that gives them their rights again, and that we need the medical certification turned in by such and such time. Then once that comes back through, then we have the designation notice that tells them if they've been approved or denied. We keep track of it on a spreadsheet for the time plus the AMS system for FMLA. So we have multiple ways to keep track of the time, but we have the process of how we do it. Any questions on that? I guess I'll walk around with it, huh?
Would you be willing to share those forms with all of us?
Yep.
Awesome.
The medical certification and for the family and the employee, we got it from the Department of Labor website. The designation notice is the Department of Labor, but the letters, absolutely. We can send you the request, the notice of possibility, and the eligibility notice. And then you put it on your letterhead. So then the employee, if they don't take the FMLA, we can't tell them that, we can't qualify them because we don't have the medical certification, but we've given them their notice. That's it.
Thank you all for participating. Did you? And we'll get with Debbie and forward out A&I's information to everybody, and hopefully people that were live streaming sent in their little bit of registration, because we have developed like a certificate of attendance so you can keep it for your records for ongoing education. And we're working with Brenda Kelly and the Halogen system so that you can go in and enter all of this training and keep an electronic record of training. So thank you all for coming.